See, notice, discovery, pre-hearing issue, then hearing issue, 1 page. That's it. Then bias, right to an impartial decision maker bias. Bias 1 page or 1 more page. Procedure is done. Procedure by 75% marks, at least 65 marks, at least 65% marks gonna come from here. Then we have to start. What is written? Substantive. How many pages? 1, 2, 3, 4. That's it. You will not gonna write all, which is a relevant. Only pick up that line. Keep continue reading. Okay. You know what? Just half an hour. Are you bored or just?
No.
Computer guys, still with me? I know. You're gonna go to the job. 6 o'clock. Okay, no problem. Computer guys, are you learning? Seriously, are you learning? Rekha, Jessita, Kvita. Thank you, man. I feel such a. Thank you. Okay. Yes, a lot. Interesting. Good, very good. You made my day. Whenever you're gonna say me, I am happy. Okay. We have done procedure. I am not happy with the decision of the admin body based on procedural grounds. Before, based on procedural grounds, because they did not follow the proper procedure. What procedure? Room number 1, room number 2, room number 3, matter is over. Then room number 4 was also there. I escaped. No, it was my mistake. Room number 4, unintentionally I escaped room number 4, unintentionally. Okay. Anyway, leave it. Room number 4 was, okay. What is the room number 4? Before we gonna make a decision, room number 4, notice, okay. Computer guys, I need your eye contact. Computer guys, do not write, I need your eye contact. Vishali, your name is Alberta Dentistry Board. Your name was Dimu. Okay. I'm a judge. You are Dimu, admin body. Room 1 is done. Room 2 is done. Room 3 is done. Come to the room 4. What is the room 4? Room 4, you're going to write exact from the point 1. Notice issue. Do you have a notice issue? No. Notice is equal to no issue. Discovery is equal to no issue. You're going to write in exam. Delay, no issue. Right to cross-examine, no issue. Openness, no issue. Admissibility of evidence, no issue. Right to counsel, yes. Right to counsel. Then right to counsel issue. Only 2 or 3 lines. Right to counsel is an issue. Then we're going to make a decision. What kind of decision we're going to make? Okay. Just 1 second. Okay. On the whole, nature of the decision, relationship between respondent, Mr. Dimu, and board, Alberta Dentistry Board, and impact on the respondent of the impugned decision, difficult decision, lead to the conclusion that do not write, man. Just write. If you will write, if I'm gonna say write, then write. Okay. Lead to the at least common law duty to act fairly on part of the board, and I would quash the decision of the admin body based on the common law, violation of the common law, and I would quash the decision of the admin body and send it back for rehearing. In the rehearing, must provide right to counsel. See, 4th room, notice, no issue, notice, discovery, delay, openness, right to counsel, openness, cross-examine, no issue is equal to no issue in 1 line, no issue. The issue is right to counsel. In right to counsel, we're gonna elaborate 2 or 3 more lines. If there was an exact issue, then we're gonna write, right to, okay, where is the right to counsel? See, in right to counsel, I have written, okay, just 1 second. Right to counsel, where is the right to counsel? Where is right to counsel? See, then we can elaborate. Right to counsel. Can you read? See, I have written right. If issue is right to counsel, you're gonna say no. Right to counsel. We have to write 2 or more lines. How you gonna write right to counsel? with the case law. Can you read right to counsel?
Right to counsel. Generally, there is a right to counsel.
Exactly, you're gonna write in exam. Right to counsel because specific point.
Generally, there is a right to counsel arising from the requirement that a person be afforded an opportunity to adequately present their case. But it is not absolute and may not extend beyond the parties to witnesses. For example, Howard versus Stony Mountain Institute.
This is a case law. See, so basically I have written every issue with one or two case law. See, okay. Due to give reason, Baker, Rail, two case. Right to cross-examine, Inosophil, or County of Strathclyde, I don't know, very difficult. Number two, one case. Okay, official notes, admissibility of evidence, one or two case. Right to counsel, Howard versus Stony Mountain Institution. So everything, openness, Millard versus Public Service Commission. So every aspects I mention the case. So you do not need to mention the case. Whole procedure is done. Whole substantive, whole bias is done. Not whole bias is done. Three left. Concept is clear. Concept is very important. Number three, I am not happy with the decision of the admin body based on substantive grounds. What is substantive ground? Computer guys, do you have any idea about substantive grounds? I'm employee. You are employee. He is employer. You are not happy with the decision of the employer based on substantive ground. What is substantive ground?
The mistake in the policies.
Do you have any idea?
Mistake in law.
Substantive mostly refer to common law in like general language.
Okay.
I don't know like specifically.
Yes, computer guys, do you have any idea? You can turn on your mic.
Substantive ground could be terms of employment.
Term of the employment. Okay.
There is a specific
No.
provision in the contract of employment.
No.
The person will
Substantive. Okay. Write it down. Still, we have 20 minutes left. Substantive is equal to jurisdictional issue. Jurisdictional issue.
Jurisdictional
Issue.
Okay.
Jurisdictional. Dictional. TIONAL. Jurisdictional issue between the admin body and the court. Between the admin body and the court. You're gonna say this case was dealt before the admin body. They do not have any jurisdiction to entertain my case. This case has to be under court. So court will decide this case. Who is the appropriate party to heard your case? For example, computer guys, I need your eye contact. Who am I?
Judge.
Whenever I'm gonna stand like this, I'm a judge here. I'm a decision maker. Admin body. Okay. Now I'm a judge here. You are not happy based on the substantive grounds. What is substantive ground? This case was okay. For example, there was a case. You enter into the tribunal. There was a case between admin body. You are fired from the job or deputation order. Anything gonna be happen. So you're gonna take. But this case has to be dealt before the court, not before the admin body. So admin bodies does not have jurisdiction to entertain my case. This case has to be dealt before the court. I didn't even know. When I go to the tribunal, open the door, tribunal job was to tell me that we do not have jurisdiction to heard your case. They must refer to the court why they heard this case. Someone told me after the final decision, they do not have a jurisdiction. I'm a judge here. You are driving 100 km in a 60 km zone. Can I give you ticket? No, I cannot give you ticket. Even I'm a Chief Justice Supreme Court of Canada. Police gonna give you ticket, right? So police is a decision maker. No, it's an investigator. So they have their own jurisdiction. So judge gonna decide based on 4 steps. based on 4 steps. Who has a jurisdictional issue? Who has a